now in session. The Honorable Richard B. Orfinger, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal said, my name is Richard Orfinger. I'm joined on the panel today by Judge William Palmer on my right and Judge Wendy Berger on my left. I'd also like to welcome the students from Mr. Moskowitz's class at Astronaut High School. Welcome. We are happy to have you back. And although we haven't told the lawyers this, after each case we'll give you a chance to ask the lawyers a couple of questions. I think what we'll do is take the first two cases on the docket this morning, and we have one civil and one criminal case. Then we'll take a break after the second case and invite counsel and the students back to the lawyers' lounge, and we'll have a chance to visit, and if things go as I hope they will, we may actually have some cookies or donuts or something like that. Let's see, the first case is a criminal case, so the parties will have 15 minutes per side to argue the case. There's a cross-appeal pending, which means that the parties will get to split their time. Let me just get my memo out and briefs. So if you will tell me how much time you would like to reserve for your rebuttal so that we're clear. You'll argue your main appeal, you'll respond, argue your cross appeal, you'll rebut, and then you get to rebut on your cross appeal. Okay? Let me get the clock set. How much time would you like to reserve?
I'll reserve 7 minutes for the cross appeal.
All right.
May it please the court, my name is Chris Davenport and I represent the state of Florida. This is an appeal, a state appeal from a trial court's order dismissing an information charging the defendant with traveling to meet a minor and solicitation of a minor. All of this occurred over the internet. The facts are an undercover officer posted an ad on Craigslist saying, "Me and sis looking for a good man teacher type." The defendant responded to the ad, asked for pictures to trade. The conversation moved on from there, got sexual. They made arrangements to meet. The defendant at one point asked, "Do you have your own place?" And the sister said, "Parents' house, but they left for a cruise. I am the boss of her." So that's what the state relied on to demonstrate that the defendant believed that the sister had custodial authority over the child, which made him liable for soliciting the sister indirectly through the adult. The trial court found that that was not sufficient, and we would submit that that's a legally erroneous finding. In a motion to dismiss, all the inferences and all the facts have to be resolved in favor of the state, and when you look at that language in the context of this sexual conversation, we would submit that that is sufficient to show that this sister was in charge of the child, and that's what the statute requires. The statute says that...
Does the statute require that she be a custodian, or that the defendant believes she is?
That the defendant believes she is a custodian. Parent, legal guardian, or custodian.
Whether that the information, whether the facts that you have just alleged are sufficient is, in your mind, a jury question as to whether a reasonable person would think, based on that information, that the person the alleged 19-year-old sister was a custodian. You think that's a jury question and not one that's subject to a
Absolutely. It should be left to the jury to resolve that, to decide whether or not the defendant believed this person was a custodian. I don't know how much more clear they can be in a situation where the officer is posing as a sister or an older mentor type of relationship than to say, I'm the boss of her. The parents were out of town, they're on a cruise. That's not went to the grocery store. Somebody's in charge of this 15-year-old when presumably, all inferences in favor of the state.
Have you ever had a 15-year-old?
I have not.
Okay, well, You might be surprised at how easy it is or is not to be in charge of a 15-year-old.
Well, to the extent anybody can be in charge of a 15-year-old, it's clear, well, we would submit that the reasonable inference is, excuse me, that this big sister was in charge of her. The parents were out of town, excuse me, and she specifically said, I am the boss of her.
Now, you left off the end of that.
The LOL.
Right? Does that make a difference?
I think, again, in taking all inferences in favor of the state, I would take that as she's conferring amusement that her parents left her in charge when she is so grossly irresponsible as to arrange sex with a stranger. That's, I think, a reasonable inference from that LOL. Now, the defendant could argue to a jury that he took that as she was kidding, nobody's ever the boss for, we're actually equals. Two different inferences. The jury would need to resolve that. In this case, the trial court did, and they resolved it against the state, and we submit that that's legally erroneous. If the court has no more questions about this custodial aspect of this case, I'll reserve the remainder of my time then, so we can address the other issue. Thank you.
Thank you so much. Good morning. Would you like to reserve some time?
Please reserve 8 minutes of my time for the cross appeal. Good morning, Your Honor. My name is William Pinnell, and I represent Evan Vitale, the appellee in this case. Co-counsel Tad Yates is also at counsel table. It's our position that this court should affirm the trial court's order dismissing counts 1 and 2 of the information. The undisputed facts in this case fail to establish that Mr. Vitale conversed with a person believed to be a custodian of a child.
But wasn't that, I mean, we're dealing with just one sentence. I mean, isn't that enough, though, that one sentence to looking at the facts as the court has to at that particular time, enough to get it past a motion to dismiss?
Your Honor, I don't think it is. The one sentence, laugh out loud, I am the boss of her, laugh out loud, does not establish custody, that this person has both custody and control of the imaginary minor child. Custodian is not defined in the statute, but it has been interpreted by the Florida Supreme Court in the Halliburton decision, and it says that custody connotes a duty or obligation to care for the other, and understood to have both custody and control of another. I am the boss of her does not establish that she has a duty or obligation to care for her younger sister.
What if the parents had left the older sister, realizing this is all fictional?
Sure.
Left the older sister and the younger child was 11. Would I'm the boss of her make a difference if the child were 11 as opposed to 15?
I think it could in a different case. In this case, I don't think it does because there's so few facts in the record to support the fact that this person was a custodian. We have no evidence that the older sister has any duty or obligation to care for the younger sister, no evidence she was the caregiver. We don't have any evidence that the parents gave her specific instructions to the older sister or the younger sister, putting one person in charge. All we have is the one phrase from the older sister saying, I'm the boss of her, but we have no indication that the parents gave any instructions to anyone. We have no indication that the older sister is even staying in the home that day. We have no indication that there's not another adult in the home. No indication
So why would the age difference potentially be relevant? If this was an 11-year-old sister instead of 15, you said that might make a difference?
I don't think it does in this case. I could see a difference.
So if it was a 4-year-old, you say in this case it wouldn't be enough because they didn't prove those other things?
Correct, Your Honor. Correct, Your Honor. We don't know who's in charge of the kid in this case. We don't know if grandma's at the house and the parents told grandma to take care of the kid.
What we have is an adult child, well, not really a child, but an adult saying, I'm the boss of her, of the child.
Sure.
The child of the parents that are...
Sure, but again, we have no indication of who's actually in charge of this person on this record. On a different record where there was more facts, there could be a different conclusion. And I disagree with the state's contention that there's nothing further that law enforcement could have said. The law enforcement officer could have said, I'm staying at the parents' home, and the parents put me in charge of my younger sister. But they didn't in this case. That would be a much closer case, and I think may be sufficient to establish the custodial relationship that's required, but we don't have that here. All we have is this 6-word phrase surrounded by 2 LLs.
So I'm the boss of is different than I'm in charge of, in your eyes?
I think it is, but I think the more important part is that there's no indication that the parents put the older sister in charge of the younger sister.
It isn't couldn't that be a reasonable inference, though? That my parents are out of town, they're on a cruise, I'm the boss of her, I'm here, I'm the boss of her, isn't that reasonable inference?
I don't think so, Your Honor, because the case law says there has to be a duty or obligation to care for the child, and we have no indication that this older sister has that duty or obligation on these facts. So I think that's the important part. There's been no showing of a duty or obligation, and we know from the Johnson case, the mere fact that an adult family member is living in the house isn't sufficient to establish custodial authority. We know from the whole case where they reversed the denial of a C4 motion, the third DCA, where there was an uncle, the mere fact that that person is an adult living in a home with a minor child. It was a 17-year-old girl in that case. They pointed out that there was no agreement from the parents giving the defendant authority over the child, no agreement from the parents imposing a duty of care, and no agreement from the parents giving the defendant authority to impose restrictions on the defendant. We have no facts in this case suggesting any of those things exist in this case. No indication that this 19-year-old had authority to impose restrictions on the 15-year-old. No indication the parents told her to impose restrictions or control her. We have her simple one phrase where she expresses her opinion that she's the boss of her. It's entirely consistent with all type of sibling relationships. The parents may have been comfortable with the 15-year-old being home alone. We don't know. This record and this chat is simply insufficient to support a prima facie case. It would have been simple for the law enforcement officer to say, the parents put me in charge of my sister for the weekend, I'm staying at the home. That didn't happen, and for that reason the dismissal is appropriate and is fully supported by the Halbert case, the Johnson case, and the whole case, and this court should affirm the decision for that reason. I'd reserve the rest of my time if there's no other questions.
Do you want to argue your second point?
Sure. Your Honor, it's our opinion that the trial court improperly denied the motion to dismiss count 3 of the information on the attempted lewd and lascivious battery. As this court has said several times, in order to prove an attempt crime, the state must show that the defendant committed an overt act or step committed in furtherance of committing the completed offense. The overt act must reach far enough towards accomplishing the attempted crime as to amount to commencement of consummation of the completed offense. Here it's undisputed that Mr. Vitale made no statements to an actual minor or even to a person pretending to be a minor. He never saw an actual minor or someone posing as a minor, and he made no movement towards making direct physical contact or towards engaging in sexual activity with an actual minor or someone posing as an actual minor after coming into that person's presence. It's our contention that under these circumstances there was no factual basis for the trial court to conclude that his actions constituted the commencement of the consummation of the completed act of lewd or lascivious battery.
Is that denial an appealable order at this point?
Your Honor, it's subject to cross appeal because it's in the same order and it's a related issue. So it is subject to cross appeal before this court today.
And why is it related?
Your Honor, it's related because it's based on the same facts that are used to support the other offenses. So that it's our position it's related in that regard. This court has addressed similar fact scenarios in the Duke case and the Biss case. It's our contention that the Duke case is more factually analogous and should be applied to the facts of this case. Because in both cases, the defendant arrived at a prearranged location arranged by law enforcement, and the Duke case relies on the Florida Supreme Court's decision in Rogers, which we think is an important decision in this matter. There's actually, even though in Duke they found there wasn't sufficient evidence to support an attempted child molestation case, we have actually fewer facts that show steps towards consummation of the crime. Unlike Duke, Mr. Vitale had no discussion with an officer posing as a minor child. In both the Duke and Bist cases, the defendant actually conversed with a person posing as the minor child. That's not the fact in this case. In this case, it was a short conversation, approximately 4 hours. In Duke, it was several days. In Duke, again, the defendant was conversing directly with the minor child and expressed an interest to have sex with the minor child. Here we have an adult who is also expressing interest in sexual activity, and the facts are entirely consistent with Mr. Vitale only being interested in engaging in consensual sexual and lawful activity with her.
How do you distinguish this case from Carlisle, which the state furnished in their supplemental authority?
Correct, Your Honor, and I included it in my final brief as well. The Carlisle decision, I think, has limited precedential value because there's very little facts in the case noted in the opinion. We don't know whether there was any direct communication between the defendant and the imaginary minor child in this case, or whether the defendant was just conversing with the adult.
Why should that be significant? If the adult is, let's say if the adult is the custodian, if we get over that issue. But, I mean, why does there have to be direct contact with the child as opposed to through some intermediary?
Your Honor, I think it's more evidence of an intent and more steps towards actually having sex with the minor if you actually have direct communication or contact with that person, with the person who's going to be the alleged victim. So it's more steps towards consummation of the crime.
Well, it may be more steps. The question is it enough steps if they have communication with some other person? I mean, the facts in the Carlisle case that are in the opinion are that we said he took significant steps towards consummating his desire to have sex with a person he believed to be a 13-year-old boy. They had sexually explicit emails and text exchanges and arranged to meet the boy and his father to engage in sexual activities. Beyond these preparatory acts, he drove to the boy's home, arriving with various sexual devices, and we said that was enough. So how is that different? I mean, on those facts which we outlined, we said that was enough. How does that differ from the facts that we have in this case, or the facts that the state has alleged, assuming again that it's an appealable order, one that I'm not conceding, but let's just get to the merits of it.
Sure. Again, there's not a lot of facts in there, and I think the facts are similar. I think the court primarily...
Well, I just outlined the facts that are there. So I'm saying, okay, in Carlisle, we said this universe of facts was enough. So tell me how the facts in your case are really different. I mean, it seems like they're pretty much about the same.
They're pretty close, but we don't know from those facts whether there was direct communication. We also don't know the distance that was traveled by the defendant before he arrived at the home of the boy and his father.
Why does that make a difference? I mean, if they live 3 blocks away and he walks 3 blocks, or he drives 3 hours, I mean, granted, you have more time to reflect, but the issue isn't time of reflection, is it a sufficient act to demonstrate a settled intent to commit the crime?
I think you're correct. The reason it's important is because this court in Bist said it was important. And I think Bist is wrongly decided. I think it's contrary to Duke and contrary to the Florida Supreme Court's decision in Rogers. But Bist made a big deal about, in its attempt to distinguish Duke, that the defendant in Bist, which was relied on by this court in Carlisle, that the defendant in Bist traveled 200 miles, and that was a greater distance than the defendant in Duke. So this court has said it's important. I think it's a distinction without a difference. I think you're correct, but the Bist court found it to be important. So to the extent Carlisle relies on Bist, our case is different. It's 30 miles instead of 200, and I think that makes it more like the Duke case than the case in Carlisle and Bist. Again, Carlisle was based almost primarily on Bist, and it's our contention that that's wrongly decided for a couple reasons. In footnote two,
You've got about a minute and a half left, so if you want some time to rebut her.
sure, I'll reserve the final minute and a half to rebut. Thank you, Your Honor.
First, as to the state appeal, defense counsel says that the police officer needed to say, "The parents put me in charge." I don't know how more clearly they could say that and still be colloquial and not sound like police officers. You know, they're posing as a 19-year-old. They aren't going to say, "My parents have put me in charge of this young child for the weekend." They're going to say, "My parents are out of town, come to our house, I'm the boss of her." That's how the kids talk today. So I think they said the same thing in a different manner. And
Would it make a difference, and I realize it's not the case, but if she writes in the text mail, you know, "My parents went away from the weekend, Grandma's staying with us, but she's gone to the movies, so come on over and let's have a big time with me and little sis."
I think in that situation, it would be tough for the state to prove that the defendant believed she was in charge of the child when there's an older adult in the home. That's more of a hanging out kind of situation. Now, I would still submit that you couldn't dismiss that because there's a reasonable inference that she's in charge at the time. But I think that would be a tough one to sell to a jury, and I think that's a lot closer
But
than
at
what
the
you
end
have
of the
here.
day, your argument really comes down to that 5 or 6 word phrase, "I'm the boss of her, LOL." And the question then is, could a reasonable jury infer from that that the defendant had a reasonable belief that he was speaking with the custodian of the child and
Exactly.
arranging to engage in sex with her?
Exactly. And
So
again,
the
the
state
LOL.
lives or dies on that one phrase.
Well, that and the fact that the parents were on a cruise, I think, helps that phrase. Because it's not just, you know, "My parents stepped out for a minute, hurry over here." It's, "My parents are gone." I mean, a cruise is not a short event. "My parents are gone. Somebody has to be in charge of this child, and here I am, the boss of her." So I think you have to take those two phrases. And again, the LOL, I think that confers amusement. You could certainly argue to a jury the amusement was that this is all a big lie, or you could argue, in my opinion, the state would argue that amusement was, "Wow, I'm really irresponsible and they stuck me in charge anyways, and we're going to get away with something here." I think that's a reasonable inference from these texts. So we would ask you to reverse the trial court's order on that count. As to the attempted lewd battery count, this court has made it clear in Best and Carlisle in this recent line of cases, and it's true in the other districts as well. If you have a sexually explicit conversation with a child or somebody who's in charge of a child, you make arrangements to meet them, and then you take that step of going to meet them at the prearranged location, and you bring along something to facilitate your intent. In this case, he had condoms and vodka, which they had discussed both of those things during the course of conversation. I think the case law is clear. When you have all of those things, that's enough to show an attempt. Certainly, it gets past, again, a motion to dismiss stage. And, excuse me, he can certainly argue to a jury that it was never my intent to have sex with a 15-year-old. I was going to meet the older sister only, and I was just using that stuff to get to her, and a jury can evaluate that testimony and what his intent was. But on a motion to dismiss stage, is this enough? Under Best and Carlisle, it clearly is enough. He talked about it, he arranged the sexual interlude, he went to the prearranged locations, he stopped at Walgreens on the way, he didn't just pull out of his driveway. I mean, he traveled 30 miles. This isn't a spur of the moment, I'm not sure what I'm going to do. I mean, that was a trek. And he brought instruments to facilitate his intent, and that should be sufficient to survive a motion to dismiss and allow us to present this case to a jury. And the trial court correctly found that it was.
Well, those things would have equally been applicable to facilitate the intent just with the non-minor, correct?
Well, except for the conversation, because during the course of the conversation, the big sister made it clear that this was about the 15-year-old and not just her. And the defendant, asked if she was a virgin, asked for pictures of both of them. He indicated an intent to have sex with the younger child as well. He offered up a threesome. I mean, he was pretty clear what his intent was. And again, he could say, I was just saying that so that I could get there, but that's something for the jury to evaluate. And the trial court properly found that it should go to the jury. If the court has no more questions, thank you.
Thank you very much.
Please support. I disagree with the state's contention that the chat makes it clear that it was all about the minor. The imaginary adult, 19-year-old, repeatedly asked, what are you going to teach us? So it's ambiguous at best. More importantly, again, it's our
Well, if it's
contention.
ambiguous, you get past the motion to dismiss, right?
On that sole issue about whether he was going there for the child or the adult, and I think that in the other cases, it was a little more clear that the defendant was going solely for a child. So I think that distinguishes the facts of our case from Bist and Carlisle. But more importantly, I think, again, it's our contention that Bist and Carlisle are contrary to the Florida Supreme Court's decision in Rogers, which was relied on by this court in Duke. In that case, you actually had a defendant who made physical contact with a live victim, squeezed her breast after telling her to take off her clothes, and they said that wasn't a sufficient overt act towards attempted sexual battery. So I have a hard time, I don't think the facts of this case are anywhere near Rogers, and that was insufficient. So I believe that Bist and Carlisle are contrary to Rogers, and this court should now follow Rogers and should conclude that the facts of this case, based on both Rogers and Duke, are insufficient, and that the trial court erred in denying motion to dismiss count 3, and ask you to reverse on that basis.
Thank you, sir.
Thank you.
All right, counsel, if you would be kind enough to